Hello, everybody. Good afternoon and happy Friday. We're going to get started. Thank you for joining us for this webinar, which is brought to you through our, that being the National Conference of State Legislatures, our partnership with the John D. and Catherine T. MacArthur Foundation. Over the last 9 years, this partnership has enabled us to create many and varied resources on juvenile justice issues, all of which, including in the very near future, the archived version of this webinar, will be available on our website, ncsl.org, in the Criminal Justice Research and Issues section under the Juvenile Justice tab. I think Gabe just told you what the official title was, but in case you didn't hear, the official title of the webinar, to make it easy for you to find, is Juvenile Life Without Parole, Miller v. Alabama, State Action. So today you're going to hear from three speakers, the first being myself. My name again is Rich Williams. I'm a policy specialist here at the conference in the criminal justice program. And for my part, I'm going to give a brief synopsis of the Miller decision, its impact on juvenile sentencing, and the questions and policy challenges it has created for states. I will also give an overview on the action states have taken since Miller to respond, both through legislative action and considerations from state court decisions. After me, it will be my great pleasure to introduce our two guests, who have graciously given their time to be with us here today. And they are Senator Rick Jones of Michigan and Representative Gerald Fox of Connecticut. They will each address how their state has or is currently addressing juvenile life without parole in the wake of Miller. And gentlemen, thank you both for being here. We all really appreciate it and look forward to your comments.
Thank you.
All right, so let's start with and briefly recap the holding in the Miller case itself. There in Miller, the United States Supreme Court held that mandatory sentences of life without parole, when applied to juveniles, that is persons who were under the age of 18 at the time they committed their crime, is a violation of the Eighth Amendment's prohibition against cruel and unusual punishment. Mandatory sentences in this case means whoever the sentencer is, the judge or the jury, is handing down the sentence. They had no discretion to charge the juvenile with a different sentence for their crime other than life without parole. To be clear on the ruling, Miller did not abolish life without parole sentences for juveniles. They just found mandatory life without parole sentencing structures for juveniles unconstitutional because they did not give the sentencer the opportunity to consider the defendant's youth, the particulars of their case, and their mental and emotional development as mitigating factors to their sentence. So life without parole sentences for youth who commit homicides can still be implemented, but the sentencer must consider their youth and related elements as a mitigating factor. The Miller decision was the latest in a series of United States Supreme Court cases, the others being Graham v. Florida and Roper v. Simmons, that have found that juveniles are different from adults for the purposes of criminal sentencing. In Roper, the court abolished death sentences for juveniles, and in Graham, they abolished life without parole for juveniles in non-homicide cases. Over these three cases, the court has found that juveniles are different from adults because they have a diminished culpability and greater prospects for reform. Because of this factor, which is directly attributable to their youth, they are therefore found to be less deserving of the most severe punishments than an adult would be. Okay, so what makes juveniles different? Articulating the foundation for these differences between juveniles and adults, the court identified three gaps. Gaps is their phrase, and they are judicially significant factors in considering youth for sentencing. And the gaps, the court says, are things that any parent would know. First, the court identified that juveniles, one, lack maturity and have an underdeveloped sense of responsibility. This, the court says, can lead to juveniles to behavior that is reckless, impulsive, and heedlessly risk-taking without the thought of consequence. And I suppose if any of you are like me and have a cousin that stuck a fork into a light socket as a child, you know that that's true. Okay, so the second gap the court identified, it said that youth were more vulnerable to negative influences like peer pressure and other outside pressures. Because youth are often dependent upon their caretaker or parents, they have a limited control over their environment, and they lack the ability to remove themselves from situations even if they are particularly horrific or abusive. And being forced to or compelled to be in these situations can negatively impact their developing behavior into the future. The thought there is that if you grow up surrounded by crime and you only know behavior, how much you have to take into consideration how much that would influence a child's development. And last, the Supreme Court identified that a youth's character is not well formed. And what the court is getting at there is that even bad acts, even bad acts when you're a child, are less likely to be evidence that you're going to be, in their phrasing, irrevocably depraved, or a lost cause, I guess, is a more normal way to say that in regular language. And bad behavior could just be a transient thing to your youth that you will lose once you mature and develop out of it. So those are the three differences the court, over the course of Miller, Graham, and Roper, identified as the functional gaps between adults and juveniles. And in the process, the court cited social science and brain development research that supported study behind those assertions. Those assertions were important because they're central to the court's reasoning for not automatically sentencing youth with the harshest punishments. In Miller's case, it was life without parole. They enumerated and talked about justifications for punishment generally, which they identified as retribution, deterrence, incapacitation, and rehabilitation. Youth, the court ruled, the aspects of youth listed from the last slide undermined the impact or justification for each of these peniological ideologies, I suppose. For example, if you're talking about retribution, a youth may be less, it may be less just to give a youth a sentence based on retribution because they may be been acting out of recklessness as opposed to intentionally and knowingly cruel behavior. Similarly, deterrence isn't as effective for youth because they do not consider the potential punishments before taking action, or at least not to the same degree as adults. And for the last two reasons on the slide, they are supported by the court's assertion that youth personality is not well formed. It is less necessary to incapacitate juveniles for the rest of their lives unless you're sure that they won't mature out of that behavior. And life without parole is also, or mandatory life without parole is foregoing any attempt at rehabilitation, which, as the court noted, is for juveniles a longer sentence than for most adults. So the court went on to surmise that upon top of all of these considerations, that when sentencing, a state is not required to guarantee eventual freedom, must provide some meaningful opportunity to obtain release based on demonstrated maturity and rehabilitation. And that in making this determination, a court must consider youth and its inherent factors, as well as the individual nature of each child's background in sentencing. Because all of this influence, putting all juveniles blanketedly, I'm not sure if that's a word, but so in mass into mandatory life without parole sentences, to do so would run the risk of disproportionately punishing juveniles, and that aspect would be what the court considered a violation of cruel and unusual punishment. All right, so what and who did the Miller ruling impact? In the opinion, the court borrowed some states from one of the briefs, but added a few more and identified overall 28 states in the federal government as having laws that had at least some mandatory life without parole sentences for juveniles. And in these states, which are identified on the map here in yellow. However, as I will discuss in a minute, for a few reasons, these are not the only states that are and could in the future be impacted by the Miller ruling. Okay. Here is my understanding of a breakdown of the three big genus or species of questions facing these and other states since Miller. The first group of considerations I've labeled as sentencing laws for future defendants. So that if you were in a state and you had mandatory life without parole for juveniles and that's now off the table, what sentences should be put in its place, or does the next highest sentence currently on the books meet the needs of the public and other constituents? The next two here is considering age. I have it labeled. In other words, when the sentencing is being decided, how does the court have to consider the youth age? What would satisfy that obligation. Is having the discretion to choose differently than life without parole enough to satisfy Miller? What if the discretion is there, but there's a presumption in favor of a life without parole sentence? And do the aspects of youth need to be addressed separately at all, or is just having the discretion good enough? This group of questions impacts any state with discretionary life without parole as well, not just the mandatory ones from the last slide. And lastly, states are also considering whether or not the Miller ruling applies retroactively or also or just prospectively or also retroactively. And that would impact about 2,500 juveniles across the country. And I'll talk more about that in a minute. On those three areas that I was just discussing, or those topics, since Miller, 14 states have enacted laws that address at least one of those aspects of life without parole. Those 14 states are identified on the map here, and over the next few slides, I'll give you a breakdown of what happened in those laws and how they play with the Miller ruling. First of these issues, sentencing post-Miller. Juveniles who commit crimes obviously will still be sentenced, and states are looking at how best to find solutions that sufficiently address the inherent qualities youth and its impact on sentencing will have while still working with the need to protect the public. On this slide, I break out post-Miller sentencing issues by the most commonly occurring sentences themselves. First, I want to start with what discretionary life without parole is beginning to look like after Miller. As mentioned before, the Miller ruling left life without parole as an option for juvenile sentencing, but expected that its application would be uncommon or unusual. So in considering future life without parole cases and sentences for youth, how are states looking at changing the analysis that goes into applying life without parole for these unusual or uncommon cases and even determining them? And for this, I want to look at the most recent that I'm aware of bill enacted on Miller, addressing Miller, from the state of Washington. And if you're interested, that bill is Senate Bill 5064. The new law, it provides sentencing breakdowns for kids 16 or 17 and then 15 or younger. But in either case, the law requires that the sentencing court take into account Miller factors, including but not limited to the age of the individual, the youth's childhood and life experience, the degree of responsibility the youth was capable of exercising, and the youth's chance of being rehabilitated. To be clear, the Washington law requires that sentencing consideration for all juveniles who commit first-degree murder, but only those 16 and up have the potential to end up with life sentences without parole. By requiring this discussion, though, of the Miller factors, it might be easier for a court to identify on a case-by-case basis which qualifies as usual versus what qualifies as unusual for the purpose of a life without parole sentence. Michigan's law, which you'll hear about in a little bit more from Senator Jones, and California's law reviewing life without parole sentences have similar provisions addressing Miller factor considerations for sentencing. Another option states are looking at to setting juvenile sentences is life with parole after some number of years. And the challenge here with this aspect is from the part of Miller that states that a state must provide a meaningful opportunity to obtain release based on demonstrated maturity and rehabilitation. So what this prohibits basically is running an end around on the requirements for imposing life without parole sentences by, say, for example, if you were to issue a sentence of life with parole eligibility after 120 years, that doesn't leave much room for parole at the conclusion of 120 years. So the question becomes, what number of years isn't too much so that it becomes the functional equivalent of a life without parole? And right now, the best example I have of a case that addresses this is from Iowa. And in Iowa, interesting, shortly after the Miller decision came out, the governor there commuted the sentences of the state's population, I think it was between 40 and 50 people, from life sentences to life with parole eligibility after 60 years. And the state's high court recently, or not so recently, but the state's high court in State v. Ragland found that 60 years was the functional equivalent of life without parole sentences, and it was unconstitutional for the same reasons given in Miller. Just as a side note of something that I thought was interesting there, the court allowed the district court's resentencing of the governor's sentence commutation down to life with parole eligibility after 25 years to stand, though they noted that that was more a matter of pleadings than an endorsement of how all these cases should be handled in the future. Anyway, just because 60 years is the line currently in Iowa, it doesn't mean it will be that in other places, or even for juveniles of different ages. Although I will say that 25 years before parole eligibility is within the range most states of those 14 before have taken as their minimum life without parole legislation, as their minimum number of years before parole eligibility legislation since Miller. As far as the lowest I've seen has been in California, again with that legislation for resentencing parole hearings, has been 15 years, but most states are between that 25 and 35 years in terms of minimum number of years served by juveniles before they'd be eligible for parole. So there's and the highest I believe I've seen for the high end of these ranges is usually around 60, right where Iowa's Supreme Court case came down. There's a good deal of diversity on this point, so I'm interested to see how that's going to develop as it moves forward. Got a little bit ahead of myself. The last thing I wanted to address was there's also a few states that have taken action to remove life without parole sentences for juveniles in general, discretionary or mandatory, as an option for sentencing after Miller. Texas had actually, along with Colorado a few years back, pre-Miller, removed juvenile life without parole as a sentencing option for anyone in the state age 16 and under. That's Texas. Colorado did it for all youth. But since Miller, Texas has included 17-year-olds as being ineligible for life without parole for what they define as capital offenses. Wyoming and Utah have also passed laws that similarly disallow applying life without parole sentences to juveniles, and North Carolina removed the possibility from youth who are convicted of second-degree murder, though they keep it for first-degree murder. There's less here to discuss in terms of Miller because there's nothing that needs to be necessarily considered along with Miller factors in terms of removing those options, but it's an option states are taking. Considering youth. So I mentioned before that Miller is having an impact outside of states that have mandatory life without parole sentences, and I also mentioned before how states are writing the Miller factors into law as considerations for juvenile sentences, in particular for life without parole. Below are two situations currently in state courts or recently decided in state courts that I think will give some guidance on how Miller factors are being used to guide discretionary life without parole sentences, and specifically what may be required beyond merely allowing for the discretion. So I'm going to turn first to California, where there's two cases currently before the state Supreme Court, People v. Moffitt and People v. Gutierrez, and I hope I said those close to right. At issue in these cases is California currently has a discretionary life without parole sentence, but the state court cases and other cases have interpreted their discretionary life without parole sentence, which is for 16 and 17-year-olds. It gives the judge the option of picking between life without the possibility of parole or 25 years to life. But cases and other secondary materials have interpreted those as providing a presumption in favor of the life without parole option. And that's what these two cases are going to be deciding. I believe it was Moffitt that decided that that was against, that fell within Miller and was against, violated the Eighth Amendment to the Constitution, while Gutierrez said it was okay because the opportunity for the sentencer's discretion was still there. The second case, the second instance I want to bring up is a recently decided Ohio Supreme Court case, State v. Long. there, although the judge had the ability to sentence an individual to a different sentence other than life without parole, because he didn't address youth specifically in the decision, the case was remanded by the state's high court. So these two cases are just, for instance, for how the Miller factors could, enumerating those and how they are enumerated could play a role in how effective future court rulings and legislation can be. All right, so moving on to the last of the three big main questions for states after Miller is the question of retroactivity. According to the decision at the time, there were 2,500 youth serving life without parole sentences. About 2,000 of those were the result of mandatory sentences. And so states want to know if Miller applies to these defendants because there's been a split as to whether or not they need to be addressed, resentenced, and what the appropriate method for that is. And as I mentioned before, in Iowa, some of the thoughts, there's been some thought about commuting sentences in the event that Miller is retroactive, but there's been difficulty with the Iowa decision. I'm not sure if the individuality aspect of the Miller ruling and looking into the child's background would be satisfied by a similar mass commutation. Okay, so on this map you'll see here is Miller retroactive in terms of the legislation that's been enacted since passing. And what's collected here for the states that are considered retroactive, there's two things. One, there's intent statements. So if in the bill it said this is designed to be retroactive and people will need to be resentenced, they're indicated there. Or provisions inside, like Washington's bill. I don't believe it mentions retroactivity, but it has sentencing provisions or resentencing provisions for their current life without parole population. Okay. Also, a number of state Supreme Courts have come down on whether or not Miller will be retroactive. And you can see here the states that are in yellow are the court has found that it's retroactive, and the states that are in blue obviously have found that they're not. I'd also like to point out the two cases, and again, Senator Jones will talk about this in a little bit. Michigan and Nebraska both noted that they were going to wait for retroactivity based upon what either their state high court did or the United States Supreme Court did. Okay, that does it for my part of the presentation. So thank you for listening. And now I'm going to turn it over to Senator Rick Jones of Michigan. And Senator Jones sponsored a bill addressing Miller issues there, which was Senate Bill 319. It was enacted last month. Senator Jones is also the co-chair of Michigan's Senate Judiciary Committee. Senator, thank you for being here to tell us about your and Michigan's experience considering these issues for Miller. The floor is yours whenever you're ready to speak, sir.
Okay, I'm actually the chair of the Senate Judiciary, and so I was given the task of making sure that Michigan came in compliance with the ruling. There was a great deal of division politically because some people on both sides of the aisle wanted retroactivity. The majority did not want retroactivity. During committee hearings, a great many relatives of victims showed up to testify about horrible, heinous criminal acts where their loved ones were murdered. And so it became a very, very strong force, including the state attorney general, who came out opposing retroactivity. It was finally decided that the best way to go forward would be to bring the law into compliance with the ruling for every case in the future, and then write into law how it would be handled retroactively if there was a court ruling that said it had to go retroactive. So that occurred, And that seemed to make all of the victims' families and relatives and friends happy. And so it became something that could politically be done. As we moved forward, we studied various cases, various laws around the nation, and decided we'd go ahead with the 25 and up parole hearing. So they would have a parole hearing available at 25 years and up to 60. And, you know, a lot of people asked, why would you ever consider having something higher than 25? And it was explained to them, you have to realize some of these cases are extremely heinous. You have a great variety of cases. You have everywhere from perhaps a 15-year-old youth who gets involved with some friends that do an armed robbery, and the armed robbery goes bad, and somebody dies. But the youth perhaps was not the shooter, was assisting in other ways. Well, in Michigan, that is felony murder, and they're just as guilty as the guy that pulled the trigger. However, obviously, that is not as heinous as another case that we had here in Michigan, where a youth decided to kill a man simply because he wanted to see what it felt like. After killing him, he cut his head off, took pictures of it, then put it in his car and drove around with it to show off. Obviously, there's a great variance in how heinous and horrible some of these crimes are. Certainly, there were also crimes of gang members who would kidnap a girl, drive around and show her off as a prize before she was sexually assaulted and murdered. So some of these things are very, very heinous, very emotional, and most of the citizens don't want individuals that have committed such an act ever back on the street. So what I've described to you is the political reality of changing a law, and we did go ahead and change it for the future. I think we've done a good job. I think it gives the judge proper discretion, and the judge will consider the factors in Miller and make sure that the sentences will hold up in future appeals. I think that the majority certainly was happy with it, although there are still some people that were representatives and senators that were not happy we did not pass retroactivity. I suspect that sometime in the future the court will rule, and then our law is set to kick in, and there will be retroactivity, and there will be a possibility of resentencing with the parole dates provided by the judge. I think that's about everything that you wanted me to cover. Are there any questions?
Well, at the end, we'll have we have a queue of questions that we're going to get to once we all speak. But just I wanted to. So, have you? I saw that there was a case in Michigan's appellate court that was considering retroactivity. Was that something the legislature was aware of at the time you considered you put that that aspect in the bill?
Yes, but we had decided that it would have to be a ruling by the state Supreme Court or the U.S. Supreme Court mandating retroactivity in order for that to happen.
Gotcha. Well, thank you very much, Senator Jones, and yeah, just wait around, and we're going to do Q&A coming up next. Okay, our final speaker today is Representative Gerald Fox of Connecticut. Representative Fox is chairman of the Connecticut General Assembly's Joint Committee on the Judiciary. The Millard bill introduced by that committee in the state is House Bill 5221. Was just voted on positively and out of the House on Wednesday. Representative Fox, hello, are you there?
Hello, yes, I am here.
Okay. Thank you for being with us. Feel free to begin when ready.
Sure, thank you, and thank you for having me. Actually, our bill was voted out yesterday, so it's not even 24 hours out of the House, and it's on its way up to the Senate. And it's a bill that was put together by our Sentencing Commission, which is a group of 23 law enforcement officials, defense attorneys, judges, who worked very hard on this issue over the last several years. And we were able to come together with a bill that received wide bipartisan support, and it's our hope that it'll get out of the Senate very soon and be signed by the governor in the near future. What our bill does is it deals with those individuals who receive long sentences for crimes they committed between the ages of 14 and 17. It is retroactive. It does, and what we did in the compromise that we reached is that if the individual has received a sentence of 50 years or greater, they would be eligible for the second look after serving 30 years, which would be 60% of a 50-year sentence. And then for those who receive less than that time, the sentence would be they'd be eligible for a second look after they serve either 12 years or 60% of the sentence, whichever is greater. As I'm sure people are aware, the basis for this was the opinions of our United States Supreme Court, where they have determined that children develop differently. They are capable of rehabilitation, or more capable of rehabilitation than perhaps adults. They are less able to distinguish between right and wrong, and though the crimes that they have committed are serious and certainly deserving of a lengthy sentence, it also is not reasonable to expect that they can serve essentially what would be a life sentence without an opportunity for a second look. We did say that we had some input recently from our Office of Victim Advocate. We have a new victims advocate, and what he focused on was making sure that we do have an opportunity at the Board of Pardon and Parole, which is where these hearings would take place, that the victim is given proper notice. The victim has a clear opportunity to express what they would like to see happen, and also that in the event that there's a denial by the Board of Pardon and Parole, that the individual would not just start applying again. There would be at least a 2-year period within which they could come back, before which they could come back. So it was felt that that type of bill would be fair to the victims, as well as still meet the constitutional requirements that are set out by allowing those who are juveniles to get an opportunity for a second look. In the same bill, we incorporated criteria that would allow us to deal with Miller, which the court would have to address at the time of sentencing for crimes going forward, when an individual is sentenced, or a juvenile is about to be sentenced for a lengthy period of time. And we incorporated the Supreme Court standards that are set out in Miller. So it would be my expectation, I think many's expectation, that going forward, it will be determined that when we do sentence juveniles, that those sentences will be upheld because of the factors that are looked at, as well as the opportunity for a second look. This was in putting the bill together, it was I was fortunate in that we did have input from all sides, and I think having a sentencing commission, which included prosecutors, included police, law enforcement, victims groups, we were able to come up with a bill that I think people felt was a fair bill. It recognized what the scientific studies are showing, as well as what the U.S. Supreme Court has recognized in dealing with young people and how they develop. And it was something that, as a result, I think that we were able to get a vote that went through by a wide margin. So I'm happy to answer any questions. I think we did look at other states as well. I know that I think 11 states, I was told, have enacted something. I know it's changing very quickly, and more states are trying to come up with ways to address these issues. But hopefully, ours will be one that people can look at as well. So
thank you.
No, sure.
Sorry, thank you,
Sure.
Representative Fox. We have a couple of questions, and the first two of them appear to be for both of you, not I guess indiscriminately. So if Representative Fox, you want to go first, and then Senator Jones, you can go next. And you both have touched on this a little bit, but there's a question wondering about the challenges of working with and dealing with either, you said, victims advocates or victims' families on this issue, and how that conversation went, and advice approaching that kind of a situation for somebody moving forward.
Well, as I said, we wanted to make sure that the victim has plenty of notice. I think in our bill it would say the victim would have notice about a year before the application is actually heard, so they'd have an opportunity to be prepared for that. We also wanted to make sure there would not be the revolving door of continuous applications, so we did put in the 2-year time limit, so that an individual cannot come back again. But it is hard. I mean, we had one case in Connecticut that was, terrible. And a neighbor, a 15-year-old neighbor, went next door. He knew he had a friend who was about the same age, and he went into the house and he killed the mother and the friend with a shotgun. And we heard testimony from the father who lost his family, and it is very difficult in these cases. There's a reason why these lengthy sentences are administered, because these crimes can be terrible. And the one thing I did stress as well is that when I brought the bill out yesterday, is that there's no guarantee that the individuals are going to get out. What it is it's an opportunity for people who take strong positive steps during their period of incarceration to potentially convince the Board of Parole that they should be given an opportunity for release, but it's not an automatic release.
Thank you. Senator Jones, same question.
Well, I think the best way for a state to address this is simply not go retroactive. When even a discussion in committees came up about retroactivity, the room would be filled. I mean, as many as 100 friends, family members of the victims would show, and it got very emotional. Now, some of these acts aren't a simple mistake. Some of them involve torture. Some of them involve horrible, heinous acts. So by taking the retroactivity out of it, we were able to move forward and bring the state into compliance. I think that's the best way to address it. And then we allowed, if the Supreme Court of either the state or the federal government comes back with a ruling, we're all set to take that into consideration.
Thank you. The next question again is for both of you, and I guess this time I'll start with Senator Jones. Questions concerning when considering this before the committee, was there any presentation of the brain science or research behind showing how kids are different than adults, or was it more than just the considerations from the ruling itself?
Well, certainly there was a presentation on the science of young people having certain different brain development than an adult. But again, it fell on deaf ears when consideration of constituents showing up and talking about heinous acts that were committed.
Thank you.
Sure.
Yeah.
And with respect to, thank you. And with respect to Connecticut, we've had a number of juvenile justice bills over the last 5 to 7 years where we've really looked at the way children's brains develop, the way that they are capable of rehabilitation and the way that if given the proper proper education, the proper structure, they are less likely to fall into a pattern of recidivism. It's something, so when this issue had come up, it was not something that we had to get into as much because it's something that I believe our General Assembly had already considered and bought into. They believed the science behind it already.
And again, thank you. And there's one more question. Again, it's for both of you. It's more of, I guess, an advice-seeking question in terms of the benefit in getting these bills moving forward. In terms of communicating with other agencies within your state, and I know you both talked about it a little bit, but if there's, I guess, key moves or key connections you made in talking to people, communicating that made these easier processes going forward, either the judiciary, as you said, your sentencing commission.
Sure. Do you want me to go first, or?
Yeah, sure. Go.
Sure. Okay. It really helps a lot to have buy-in from your law enforcement, from your victims groups, and also in reaching out to other legislators who may be attorneys who practice in criminal defense law. That was helpful to me in perhaps assuaging the doubts of other members, and I think it'll be helpful to anyone. And also I thought it was very important to point out yesterday on the floor of the House repeatedly that this is not a guarantee by any stretch that an individual should be released from prison. It only recognizes that at the time the crime was committed that they were of an age where they may be able to rehabilitate themselves, but they will have to have shown that they've actually done those things.
Thank you, Senator Jones.
Yeah, I think certainly we had communication with the judges groups, the victims groups, law enforcement, being the state police, the Sheriff's Association, the Chiefs of Police Association, and they all were able to give their viewpoint. I think that it's a political nightmare to go back in time, but certainly going forward, we're able to do it. It makes sense, and everybody, I think, came out of it thinking that we'd done the best job we could for the future, and we look forward to seeing what the Supreme Courts decide on retroactivity.
Okay, thank you. The next question is one that I can answer. It's just about where information from this slide will be and other resources. So like I said in the beginning of the presentation, the archived version of this will be on the website. My email is up on the page at the moment, so if anybody has particular information they'd like more of, email me and I can get you some more resources. In addition, at NCSL we're working to bring more resources addressing the juvenile brain science issue and Miller v. Alabama and related information to you. We have an online database of juvenile justice laws that you can access, and we hope to have a session at our legislative summit in Minnesota on the issue, and potentially after that releasing also a briefing paper on the issue. But other than that, it looks like that we are fresh out of questions. So I just want to say again, thank you, Representative Fox and Senator Jones, so much for giving your time. I know you guys are both really busy. And thank you again to the John T. and Catherine D. MacArthur Foundation for enabling us to do this work. And thanks again to everybody out there who's participating live and to anybody who's listening to this recorded. Thank you and have a great weekend.
Oh, thank you very much.